Welcome to Maine's podcast for July 29th, 2025. Filing class action suit claims. Are you leaving money on the table? To guide us through this very important topic, we are joined by Jim Tharin, CEO of the Chicago Clearing Corporation, to explore the often overlooked world of class action filing. From securities and antitrust cases to consumer class actions, Jim will share how RIAs, advisors, and hedge funds may be missing out on a significant monetary recovery by not actively participating in these settlements and how this can be avoided. I'm Robert Akeson, president of Maine and the moderator. And for those of you who don't know much about Maine, we are a trade organization and networking group that focuses on the needs of startup, small and emerging managers, hedge funds and RIAs, as well as public and private digital issuers and the ecosystems that support them. We're committed to bringing high value, low cost content and networking and business opportunities to these market participants. We are also very interested in what our members and audience think, so we can make our programming more relevant to you. For those who want to start and grow money management firms, Maine is the right place to be. Now, before we start, I do want to thank our sponsors, and you can see them on the page here. I won't read out the names, but I do want to introduce our panelists. Jim Tharin is founder and CEO of Chicago Clearing Corporation and is a visionary in the class action claim recovery business. With roots on Wall Street and in the CBO trading pits, Jim brings deep market knowledge and over 3 decades of experience helping institutional investors, RIAs, and hedge funds recover the money they are owed from securities, antitrust, and consumer class actions. Under his leadership, Chicago Clearing Corporation has filed more than 17 million claims and recovered over $3 billion for clients, representing $7 trillion in assets. Now, Jim also chairs the SIFMA Class Action Working Group, which he founded, and has served as an expert witness and advisor to the FTC. His insights have been featured in major media outlets, including the New York Times, NBC News, and Cranes. Now, just a reminder to the audience, Jim will be answering my questions for half an hour, 45 minutes, and we're going to open it up to the audience. However, at any time, if you'd like to ask Jim a question, you can simply do so by entering the question at the bottom of the Zoom screen there. So let's get to it. Jim, where did class action litigations come from? What's the history of all this?
Good afternoon, everyone. Thank you, Bob. Can you hear me, Bob?
Yes, sir.
All right, everyone. Just so you know, I'm shrouded in dunes and it's raining and I may lose you, but if I do, I'll get back on. And the last time I saw Bob, it looked a lot like today. The rain was pouring in Manhattan, and it's similar right now. So curiously, when one thinks of the Vikings, they certainly don't think of pristine lawyers, right? But the original class action essentially started in Iceland with an event that they used to call the Ting. And the Ting was a gathering of all the various tribes. And I think everyone who's familiar with the Vikings know how their feudal, so to speak, system worked. So the townsfolk that had a beef with a local lord would come to the Ting, and they'd take their grievance to a tribunal of lords, and the tribunal would determine the outcome of their grievance. And that was the original, that's where class actions began. Fast forward now to the US and the securities laws that you're all familiar with, 33, 34, 38, and Rule 23 in particular. Rule 23 defines the requirements for class actions, things like numerosity, similarity, etc., to determine how we're all similarly situated. Over time, and that was 1938. Over time, there's been various litigation and court cases. The most significant one was the Public Securities Litigation Reform Act of '95, which laid out and defined the process. So it took this rather unwieldy process and codified it. Now notice I said public securities litigation reform. This does not include antitrust, consumer fraud, et cetera, et cetera. This only has to do with Securities This Act. So the Wild Wild West somewhat still exists when it comes to antitrust cases, which we'll talk about briefly. But in the U.S., these securities class actions are entrenched, ingrained, and essentially permanent in the system.
So Jim, you mentioned U.S. and I think, of course, you opened up with ICE the story of the roots of class actions within the Viking world. How do class actions in the U.S. differ from the rest of the world, and why should we be concerned or informed about that?
Right. So the U.S. is the only jurisdiction that actually has a Rule 23, right? So nowhere else in the world is it legislated, and Rule 23 is 1938, so we're closing in on 100 years. So nobody else in the world has that. So we have it as part of our system. So here's
not even Iceland.
They're still duking it out.
Okay.
So, here's some of the differences, right? In foreign jurisdictions, like I said, there are no laws like the US. Lawyers cannot solicit class members. Every single one of us in England would have to find a lawyer to file a grievance, a claim against, BP, let's say. There's still a loser pay system there. And the primary difference is in Europe, you have to prove that you relied on false and misleading statements that were made by, some executive. You have to prove that you relied on it. So let's say you're an ETF. You can't prove that because you just bought a stock in the S&P 500. So you're not eligible. In the US, the biggest difference is there is no reliance required, right?
Okay.
We are presumed to all have relied on the same universal information, sort of the efficient market theory in a way. But we presumably it's out there and we all relied on it. So these false and misleading statements, presumably we all saw.
Yes.
So we don't. So we all have the same shares. We bought and sold in the same exchange. So we're all similarly situated. And in the U.S., lawyers can solicit class members and form a class. That's the primary difference.
And so you indicated earlier you referred to the 33, 34, and 38 acts. So it sounds like this is part and parcel of an overall regulatory scheme here in the U.S. at least. How exactly does that process work here in the United States? So, for example, if I'm an investment advisor or a hedge fund manager, what should I know about the process in generic terms?
Well, Bob, you and I talked earlier about how you get these notices, right?
Now, please don't share with them the fact that when I get the notices and my wife turns them over to me, I do nothing with them. Okay, please don't tell them that. But
well, let me answer. Let me get to that first, then, before how it works, because I think it's very interesting. We, I gave a presentation to SIFMA a few years ago, and we looked at we went through a whole assortment of cases, looked at all of the notices that were mailed versus all of the notices that were filed, and it was like 4.2%, right? So Bob, you are.
I'm sorry. Say that one more time. Go back to that. What's the 4.2%?
4.2% of all eligible claimants actually filed a claim.
Oh, really?
Yeah, and I'm talking retail and institutional.
Oh,
yeah. So
what about fiduciary duties?
Right. Well, that's probably 3% of the 4.2. So it's people. Don't feel alone. Everyone throws these out, right? And the fiduciary duty really only comes in if you're, let's say, a bank trust, a pension fund. Brokers traditionally don't
Right.
consider themselves
But what
having a
about a hedge fund? What about an investment advisor?
hedge fund does not have a fiduciary duty to
Okay.
file. They have economic reason to file.
Okay.
Registered investment advisors, one can argue both ways. Naturally, I think they have fiduciary duty, and most of them claim to. So very few file is kind of the point, right? Because, and so getting to your question specifically, it's like, why is that? Well, it's experience, right? Anyone who's tried to fill out one of those claim forms, and let's look at it first from the retail side. Anyone that's tried to fill out one of those claim forms know that the time and effort versus reward is out of whack. I mean, you
Okay.
have to spend, go ahead.
So I'm just gonna ask you a follow-up question here. So you know, since you and I began having conversations, I have looked more into this, and again, I've spent several decades within the securities industry, and it was interesting when I did my little survey because you and I had discussed, or you had informed me that not all brokers, right? So most of the shares are held in street name. They're not registered in the name of the actual shareholders. They're held in street name, right? Therefore, doesn't it become the responsibility of the broker dealer that faces off against the issuer? In other words, that's holding the shares in nominee name at the depository to somehow facilitate this process.
Well,
Just like shareholder communications, right? Shareholder communications is the same way, right? The broker dealer that represents the beneficial owner has a duty under SEC rules and regulations to facilitate communication. So does that apply here or not?
the brokers traditionally, well, yes and no. The brokers traditionally have felt that their only obligation is to notify their clients that they held the
Okay.
shares. And this is where this comes from. So, even though I just mentioned that it is, securities class actions are, sort of are born out of legislation, they're not regulated by the SEC. So, everything, Bob, that you were kind of talking about when it comes to fiduciary duty has an SEC regulation component to it, right? Class actions are governed by the individual courts that they are brought to
Oh.
and settled in. So the court directs, and that's the word they use, and please look it up and tell me what that means in legal terms. But the court directs the broker dealer, nominee to get the
Yes.
notice to their individual shareholders, because, like you say, everything's held in street name. DTC doesn't know who holds shares. Only the individual brokers or wherever custodians know. So they're directed by the courts to get the notice to the class members. And traditionally, until recently in particular, that's all they have done.
Yeah, I'm just referring to, I have my Black's Law Dictionary out looking. There actually is a legal definition for direct, but we'll come into that later. This is fascinating. Wow. Very
Right. So
fascinating.
they don't file. So brokers themselves don't file. Now, to get to your fiduciary responsibility point again, the you know bank trust, pension fund, et cetera, anyone who has an actual duty will file or should file, or they're taking
Okay.
a risk if they don't. But everyone else, it's for the brokers, it's a direction. For the hedge funds, it's, an economic decision, really. I mean, if they don't
Okay.
file, they're leaving money on the table. Could someone come after them? Yeah, but has anyone? Not really.
So if I can, Jim, go back to the point you made a moment ago that I think you said 3%, something like that, actually file the claim 3.5%. So what happens to the money? What happens to the money attached to those that don't make the claim?
Right. So there, for each one of these federal class actions, there, in the end, there's a pool of money, right? Not a per share amount, a pool of money, because oftentimes the false and misleading statements occur over time. If you think of Enron, they were making false and misleading statements for years, right? So you could have, it's not a date certain. So, when you file a claim, you have to file it over the course of time. As you know, file the claim form over the course of time. The money in the kitty, so to speak, gets distributed only to those that file. So it's called a pro rata distribution.
Yes.
Everyone that files gets their pro rata amount. Everyone else gets zero. You know, and awkwardly stated, it's kind of a pay to play game, right?
Sure.
You or play to get paid game. You have to file to get paid, and whoever files will share that pool of money.
Okay. Very
So if you don't
interesting.
file, you're just giving money to somebody else, essentially.
Right. So is there a time limit on this?
Well,
So in other words,
every
these funds do not, if I just correct me if I'm wrong, they do not go into some type of escheatment.
well, not the fund itself. So here's what happens. So first of all, these things take 5 years, and so we may get to that later, how long the process is. But even from the claim filing deadline to payment, it averages more than 18 months, almost 2 years. So there's a claim filing period, right?
Okay.
And that claim filing period over under is about 3 months. Can be less, can be more. But over under is about 3 months. So you have 3 months to file the claim. Once you theoretically and presumably, when the claim filing deadline passes, you can no longer file the claim. But again, this is not what everyone on the phone is used to, you know, with all the other corporate actions, you know, the reorgs, et cetera, that you got to get it in by 5 p.m. or you don't get, you know, like a voluntary or something like that. So in this case, you generally and quite often can continue to file what are known as late claims. And oftentimes you can file up until the distribution order is being prepared. So you have a little leeway on the outside, but the claim filing period is typically around 3 months.
So if you don't file and you miss these deadlines, you're not really leaving. You're not just leaving money on the table. You're losing money.
Yes.
Okay. That's the now it's clear to me. Okay. So
Well, theoretically, it's your money, you know,
that's what I'm saying.
right.
It's your money, right? But if you don't act on a timely basis,
Right.
as you pointed out, it'll be distributed on a pro rata basis to those that do file a claim. Correct? Yeah.
Correct. Absolutely.
Okay. This is
And again, let me reiterate why, because that doesn't seem fair in some ways, right?
no.
But the way a class action works is you have to have false and misleading statements being made, right?
Okay.
And the stock price, and then when the truth comes out, the truth will set you free, right? And the stock price drops.
Yes, sir.
So you almost always need to have a stock price drop in an accounting fraud 10b5 federal case. And that stock price drop means that you lost money and you base your investment on what somebody said. And, you know, they were not telling the truth, presumably.
Sure.
So stock price drops, but these statements occur over time, right? So I think Enron's a great example. If you think about how my son was listening to a podcast about Enron, and it illustrated this so perfectly. They were doing their dirty deeds for a long time, right? So every time you bought shares based on what they were saying, nothing to see here, what do you mean accounting? I mean, no, that we do, of course we're good. And so, you know, they said that over the course of 5 years or so. So it's not a one-day event like most corporate actions are. So you have to file a claim with trades that occurred over time, and there's an equation that the plaintiff's attorneys create each and every case, generally having an inflation table. If you bought on this date, sold on that date, you were harmed by this much. You were harmed by $1. You bought on this date, sold on that date, you were harmed $2. So you have to actually file the claim, right? Because again, DTC doesn't have the records. Nobody has the records.
Right.
Only you.
The party that has the records maintains the stock record, right? And
Yes.
that entity would be the self-clearing firm, right? The carrying firm for that account would have those records. That's the only records related to beneficial owners, correct?
Well, yes and no. I mean, technically yes, but realistically no. So you can also get this data from accounting software systems.
Okay.
So accounting software systems, like the old SunGard, the old Advent, they and various others. I mean, many, many others. If you have an accounting system, they will have those trades, the buys and the sells, and the positions in the system. So it's not only the custodian that can, generate the buys and the sells and
But
the
they're not going to
position.
see John Smith. They're going to see they're going to see Bank of America or Goldman Sachs name, correct? They're not.
Who's they?
So the software, does the
No,
software have access to?
well, no, let's say this gets back to your fiduciary point. So let's say you're a bank wealth manager,
Okay.
right? And your bank trust department, wealth management department, you're using one of the major softwares to run that for you. Those major softwares hold the buys and sells,
Okay.
and the administrator doesn't ask where you held them unless they ask you for supporting documentation later. But they don't ask you where you held them. They just want to know your buys and your sells.
Got it.
So, let's say you filed, pick any, sort of regional bank, US Bank, Fifth Third, Huntington, all those kind of banks will have that information, and they are the custodian actually in their case, but they have the information, and they run it through almost always the software system that you can get the data. But think about any RIA out there. They're also going to use a software system. Let's say Black Diamond, Tamarack, Orion.
Sure.
There are plenty. There are a lot. I don't mean to single anyone out, but they also account for what they do. Because think about it, an RIA might have 50 custodians, right?
Yes.
So they have to account for all of that somewhere. And so they account for it through their accounting systems, and their accounting systems have the data.
Understood. And so, Jim, I would say at this point, you have clearly established the case, clearly, why this is important. Okay. And I think you've also maybe sympathized a little bit with those of us that maybe haven't taken appropriate action or enough appropriate action to protect our own interests here. What would you recommend? I mean, so for example, this is your business, right? How can you help here?
Right. So, if you are there are different members of the audience. You have retail, you have hedge funds, you have RIAs. So,
Yes.
let's do it. Let's
And by the way, you also have brokerage firms that might be
brokerage
represented.
firms. Let's have two different types here. Let's have a retail investor and then asset managers of any stripe, let's say. So, and frankly, the process is the same for both, right? You got to follow 110 notices a year. There are 110 settlements a year. The claim filing periods are often ancient. I mean, you could go back easily 10 years. So you have to collect all that data. You got to find all the buys and the sells, the positions, and opening positions, closing positions, which are going to include a lot of noise, transfers in, transfers out, option exercise, assignment, et cetera, et cetera. So you would be required to put that claim together somehow. So you'd have to, if you have clients, you'd have to, let's say you have 10,000 clients, and they're all in Apple, you've got to put together 10,000 individual claims yourself, right? If you're an individual, you have to go back 8 years, try to find your data. Good luck with that. It's not going to happen. So you're not going to file. And on the institutional side, if you must file, it's still a very arduous task because of so you have 110 cases a year, all which take 5 years to pay. So you're dealing with 500 claims in any given time potentially, right?
Yes.
If you're in if you're big enough and in a lot, so it's just not realistic.
It's overwhelming.
Right? It's very overwhelming, and you're going to make a lot of mistakes, and maybe someone will find out about those mistakes.
Yes.
And that's not a good thing for you.
No.
So well, really, when we started this we started in 93, and it was with class action coupons, but we started filing class action claim forms in '05 on an option antitrust litigation because I was a market maker on the SIBO. So, we learned about it and we started filing the option antitrust litigation, which is another story that we might want to talk about, the difference between antitrust and securities. But we started filing claims way back then. And when we started filing these claims, there was no template. We made this up. We created
Yes.
everything that we have all the software, got all put all the clients
Jim,
together.
are you saying that from the time that these rules and regulations were promulgated and effected in the 1930s up until the founding of the Chicago Clearing Corporation, that this was sort of the Wild West in terms of who did what when it came to class action suits?
Yeah, no one really filed them. And I think it was Enron probably that sort of alerted everybody that
Okay.
this the Enron WorldCom. There are a couple at the
So then from 1935, let's say, to 1995, that's 60 years, right? In
Right.
as much as there were class action suits, which there were, I'm sure, right?
Yeah.
Whoever filed claims properly, okay, they got to whack the pie up, so to speak.
Yeah, to echo that, when I was standing in the Xerox pit on the SIBO, there was a stock called West Point Pepperell.
Yeah, I remember.
Only old timers would remember that stock,
Yep.
right? Guy named Farley owned it, and it was back in the days of Drexel Burnham, et cetera. And so this was a leveraged buyout that went wrong. All right.
Okay.
And the stock price dropped precipitously. The guy standing next to me, and this was, I don't know, early 90s, 90-ish. The guy standing next to me filed the claim. I did not. He got $350,000. I got zero. Right. So there were people filing claims back then,
Yeah.
and there was one clearing firm, I think it was SOC, Securities Option Corporation, that filed claims for their market makers. No one else, though. You had to file on your own. I didn't know anything about it. So people were filing, but there was no organized claim filing company really until us, and some others started at a similar time. So until, let's say, '05, no one was organizing claim filing.
Wow. So only the people that were really alert to this issue could act on it.
Right. I mean, they would get the notices, but
Right.
everyone was, it was up to you to decide how to, what to do. So, and that's, no one filed. I mean, the filing rates 30 years ago are much lower.
Wow.
Yeah, if you can believe it, it can go any lower, essentially.
And so go back to what you said a moment ago, that there are multiple, let's say, groups represented on this call, right? You have hedge fund managers, investment advisors, broker dealers. Okay, it's a professional crowd. What should they do if they're just receiving these documents in the mail? Okay, how can they more efficiently and effectively file their claims?
Right.
If they're just receiving the package, let's say, as I do. Okay.
Right. So,
what would you recommend?
Right. We're not, we're not the only claim filing firm out there, though there aren't many.
Okay.
But I'm the only claim filing firm that I'm aware of from, right? I mean,
right.
I'm not representing those other guys right now, but so you really need to hire a third party claim filer, frankly, because there's no way you're going to do it yourself.
Okay.
And
So how does one do that?
Well, finding us is not hard. If you're a broker dealer, I think you know who we are. I think most of your institutions know who we are unless they're newer. So I think it's pretty easy to find us.
So yeah, the broker dealers, right? They have less of an excuse to not know about this, right?
Right, because they have to notify anyway.
Right. So what about the investment advisors and the hedge funds, which are a step or two removed from that back office infrastructure? I'll say it that way.
Right. They are receiving notices, presumably, but
from the brokers.
Yeah, it's just some from their custodian or their prime, but they're just tossing them like everybody
Now,
else.
can a customer hire you?
Yeah. Oh yeah.
Okay.
Yeah. So we have a lot of hedge fund clients, 4 of the 10 biggest in the world. And so what we do for them, right? So let me talk about some of the steps that you need to go through.
Please.
So you certainly need we need to collect the historical data. Obviously, CCC tracks every case. Um, and everyone knows this, including the DTCC, which we are very close to and getting closer. So we track every case that's out there from start to finish. And again, there are 110 settlements, 250 or so litigations, and I'm only talking about 10b5. I'm not talking about antitrust cases, direct payment cases, et cetera. So this is just federal cases. You need to get the historical data. So, the primes will, better or worse, depending on the prime, have historical data that you can retrieve, or you can get it out of a software system as well. So we need to retrieve the historical data. We try to go back as far as we can. We can either comprehensively get the data or push the QSIPs that are out there, right, to you. And then you can pull the specific data if you choose. A lot of hedge funds have their own proprietary systems, and they get, a lot of our hedge fund clients send us data themselves, right? They don't use a third party necessarily.
Okay.
And so we can push the QSIPs to anyone to tell them, what's available to file for, what the time periods are that they need to pull. They pull that data. They send it to us. There's obviously, everything's SFTP secure, blah, blah, blah. We get the data. We index the data, normalize the data, and prepare it for claim filing. We then put the filing together, right? All the buys and sells, the opening position, ending position, the receives, the transfers in, transfers out, et cetera. And we beautify the claim, so to speak, to make it all balance. And we file the claim electronically for our 3,000 clients who have 42 million beneficial owners. So we have this massive software system, that can easily, quickly identify what we need, put together the claim, file the claim. And then once the claim is filed, you sometimes will get administrators asking for this, that, or the other thing. So we communicate with the client if we need to. Fortunately, it doesn't happen very often. We report all this on a portal that is unique to every client. Included in that reporting is a pro rata projection. We project on our reporting site what each client will receive, and one step further, we offer to buy it. So if you want your money now instead of 2 years from now, we will buy that claim from you. Then when the money comes, we collect the money and we distribute the money per the direction of our client. And sometimes it runs through the software systems and there's a check loader, et cetera. And sometimes it's just a wire to the client. Most hedge funds is just a wire to the client.
So let me ask you this. How many shares owned would typically make a filing worthwhile, generally speaking? And maybe it's not about shares, it's about the value of those shares. But you see where I'm going with this, right?
Yeah. Well,
any thought on that?
Yeah, it depends on who we're talking about. Let's say if you're a broker dealer,
yes,
and you're doing this for your clients, there's no skin, there's no skin off your back. We're filing every single claim for every single client, whether it's like a dividend. I mean, I don't think you throw the dividend check away. You know what I mean? So, and it really is like that for a retail client. I mean, I trade still and I get checks from Chicago Clearing. And let me tell you something, it's better than money in the dryer. I mean, think about $20 you find in the dryer. You're like, holy cow, I just hit the jackpot, But I get checks for thousands of dollars from Chicago Clearing Corporation. 4 or 5 times a year, right? So it's nothing to sneeze at. If you're a hedge fund and you're trading a lot,
by the way, how many of these class actions? I don't think you've mentioned that. Maybe you have. But how many typically happen during the course of a year? Is there any
well,
regularity to it, or is it just
yeah,
all over
I
the place?
let me tell you something. It's shockingly regular. That I would, when we used to do coupon settlements, they were totally irregular, highly irregular, choppy as can be. Securities class actions have been, I don't know, oddly similar year in and year out. So there are 220 to 250 filings and 105 to 120 settlements. And the pool of money every year over the last 10 years almost has ranged from $4 to $5 billion. Some years it's a little over 5 billion. So let's call it really 4.5 to $5.5 billion. The over under 5 billion. So there's $5 billion out there to grab every single year. Now we haven't talked to antitrust, but antitrust like FX, CDS, Euro Yen, Eurobor, et cetera. Some years, like with FX, it can be $5 billion also. So, there can be $10 billion to claim in either securities or financial cases
I'll
that are
tell you,
out there.
Jim. In my next life, I want to come back as a commission broker for the Chicago Clearing Corporation. It sounds like really a completely overlooked marketplace. I mean, it's very interesting. Let me ask you one additional question. What about private securities or hybrids like a pipe? Okay, are they subject as well to class actions?
Not in the same way as securities class actions. We see like pipes, feline prides, weird stuff every now and then, but they're mostly really private litigations where you'll have
Okay,
maybe 50 class members. So they're not quote unquote securities class actions. They do exist, absolutely, and they are more like 50 players, and it's kind of private litigation. So what happens there is that a lawyer will find out about it, a plaintiff's firm will find out about it, and then they'll put together a lawsuit, and they try to find the people that held these pipes, which isn't the easiest thing, right? Because they're pretty obscure.
sure.
Pipes is just one example. There are plenty others like that. And generally, you're only going to have 25 to 50 class members. So they file a private litigation, really kind of a mass litigation. It's not a class action per se, but they're out
What
there.
what if I'm a shareholder and I feel aggrieved by the corporation? Uh, can individual shareholders take the initiative and file these class actions?
Well, not an aggrieved shareholder wouldn't file a class action. What they could do is serve as lead plaintiff.
Okay,
And we have plenty of, if anyone can call us and I can refer them to various plaintiffs firms. But what they could do is file what's known as a private litigation, which I just mentioned. And what would happen is probably the lawyer would see your case. They'd say, huh, that's interesting. Who else held this? And they'll go and try to find those people. And then they have a lot more clout to settle a case if they have then, and you can share the costs. Because there are going to be costs in that instance to some degree if you're going to file a
right.
private litigation. Um, but oftentimes it'll be well worthwhile. See, that's one of the things about a class action. That's another difference that I didn't mention between Europe or let's say overseas foreign and US. In a US securities class action, the plaintiff doesn't pay a dime. All the risk is on the back of the plaintiff's firm. In European or overseas mass actions, occasionally they'll start asking for money. Okay, we're at this stage. You need to put up X, or I can't file for you. So, it's different case to case over there, jurisdiction to jurisdiction over there. But quite often, you're going to have to come up with money to file any kind of case in Europe.
Okay. And let me just circle back for a second to a topic that you did cover, and I just want to make sure that we're clear on this. In situations, what about discretionary accounts where the assets are bought and sold by the financial advisor? Does the financial advisor have a duty to respond to the class action lawsuit?
Well, I believe so, but some don't.
Okay.
And it's easier for them in that case. It's easier for the firm with discretion because they don't need to go to the client, either once with a blanket or individually to ask if they can file a claim. They just file the claim. I mean, when you get right down to it, every bank trust, that's what it is. And that's another difference between Europe and the US. If you're a bank trust department, you can't file as a fiduciary. They want you to get the person that, you are fiduciary for to claim that they relied on the statement, but they're not the one who made the investment.
Okay.
It was the fiduciary who made the investment. So it's kind of thorny. But in the US, the fiduciary has every responsibility to file that, and really a duty. So and they don't have to ask you or me if we have that kind of arrangement.
Right. And where do you see this business? I'll describe it that, or maybe a better term would be, we'll call it an industry. Where do you see this heading? What does the future look like for class action suit filing, et cetera?
Well, curiously, it's like I mentioned before.
Regulations on the horizon, that type of nothing. Okay.
No. Curiously, it's going to remain the same. It's just suddenly, and this is sort of inside baseball, and maybe this is fodder for another podcast because it really affects the brokers. Direct payments in Delaware have come about, and that's created real stress on the asset side of the brokerage firm because, like we all know, they don't know who held it. DTC, let me say, doesn't know who
Yes.
held it, so they've got to rely. They send the money directly to the broker because it's a date certain merger date. They send the money directly to the broker, and the broker is responsible for distributing the money. And this happens many, many years later. So the broker has to chase down all sorts of closed accounts. In addition, if there's shorts on the books, they may have to chase them. They're taking losses there. It's a mess. But what it has done is waken the sleeping giant, really. So suddenly brokers are like, whoa, what's this class action thing? And now they're starting to pay attention, and they're starting to sign up. So that's the
Interesting.
difference. I think it's just broader acceptance and broader participation is really what's changing in the industry. There's nothing in the courts that I'm aware of. There's nothing in the legislative body, Congress, that I'm aware of. What has happened, though, which is a real annoyance, is the SEC has started filing some of these cases themselves. And get this, they ask for proof for every single trade.
Oh,
Bob Akeson would have to find hundreds and thousands of individual confirms going back 10 years
oh,
and supply that.
that wouldn't, my filing system is just so crackerjack. I'd have no problem with that, right?
Yeah, everyone's is. They're all
That'd
crackerjack.
be easy. That'd be easy.
I don't know why the SEC is shutting people out because that's essentially what they're doing. So we have a new committee starting up in September to try to address this because
This is at SIFMA?
Yeah, it's really contrary. It's the SIFMA working group on fair funds. It's
And
really,
if you don't mind, just for the benefit of those that are not so familiar with SIFMA, what exactly is SIFMA?
well, SIFMA is the organization that represents broker dealers, essentially
Just like a
custodians.
trade organization for broker dealers.
It's a trade organization, and the members are the ones that pay for and support the DTC, essentially. So every notable broker dealer custodian is part of SIFMA.
Right. So there's like 3,800 broker dealers that are permissioned by FINRA to do business with the public, of which maybe 250, I think, something like that, are actually members of DTCC, which means they also own a pro rata share in DTCC. That's the universe that you target on the broker dealer side, it sounds like.
Yeah, it's the 250, and then
Yep.
others that might want to join. But yeah, if you're a DTC participant, you're part of SIFMA.
Understood. Wow.
And so yeah, these fair funds are absolutely contrary to the charter of the SEC, because they're shutting out the small guy without question, and they're shutting out the big guys too. But the big guys sometimes have the wherewithal to do this. The small guys do not. You, me, our mom, dad, son, daughter, we can't do it. So they're shutting us out completely.
Yeah, that's very interesting.
It's
And
sad.
if not alarming,
It's alarming.
you know. Wow.
Well, you asked for trends. Those are, direct payments certainly in Delaware is a trend. Fair funds are a trend. Um, no, foreign litigation is, plaintiffs' attorneys are very clever people, and they're figuring out ways. Curiously, they get around the solicitation by having litigation funders in Europe. It's a much more established business than it is here. And if you remember, a month ago when the tax bill was passed, Tom Tillis was adding legislation to make it very difficult to be a litigation funder. Well,
Yes.
that didn't make, for reasons everyone can guess, that didn't make it to the final bill. So it looked like it was going to, though, actually. But so that's how the Europeans, have grown, is through litigation financing. And I think Europe is changing without question. And
What do you mean change? Changing in what sense?
they're discovering class actions. They call them mass actions, but because of the litigation funding, suddenly the attorneys aren't the ones soliciting the client. The attorneys are not, the ones that are paying for the lawsuit. It's the litigation funders that are soliciting clients and fronting essentially the cost of the lawsuit.
Okay.
Right. So in the US, the plaintiffs firms by and large front the cost of the lawsuit because there are, 20 or so that are absolutely established, have made, a lot of money over time, have a pretty large war chest to, take 5 years to settle a case. So in Europe, they don't. So the litigation funder is the one who is supporting these cases.
Okay. And so for someone like you or a competitor of yours to provide this frankly valuable service, how do you get compensated?
Purely contingency fee. So, well, not purely. We have flat fees also, but we only get paid when our clients get paid.
Okay. And let me ask you something else. What happens? You mentioned before that it takes several years for these matters to be resolved and for payment to take place. Um, and let's say I want to get my hands on my money faster, right? What happens if, how do you know, like at what point are you willing to extend credit in effect to a shareholder? I mean, you must at some point either the matter must be resolved or you must have good reason to believe it's going to be resolved. Does that make any sense?
Yeah, I mean, it's really a step further. We put together the claim, file the claim, and then we'll put a price on what we will pay for that
Okay.
claim. But hedge funds, there are two things about hedge funds. They're either going to die or become a family office, essentially. So very few. How many have actually lasted 30 years? I think it's less than five.
Yeah,
It's a handful maybe. So, and how many have become family offices? Well, quite a few. And
yeah.
how many have gone out of business? Well, most by far. So,
It can be a rough business. Yes.
yeah, when you go out of business as a hedge fund, you have assets that you need to liquidate and you need to liquidate quickly. So if you have one of your contingent assets, which you may not even know you have, is a class action claim or series of class action claims, a book of class action claims. And so we will buy those with absolute immediacy. So, in the terms of the world,
Sure.
so that somebody can, that last employee at the hedge fund can cash out. And if you don't do that, you may get in trouble from your partners, investors, if you don't maximize your assets.
Right. Right. Or if they know about it.
Right.
Wow.
Right.
Very interesting. So Jim, in the closing time that we have, or the remaining time that we have, do you have any parting thoughts that you'd like to convey to our audience here? I mean, we've covered a lot of territory. I think this is certainly one of the areas within the industry that are less well known, or is what is less well known. So what would your parting thoughts to the audience be here?
Well, I would like to add one thing before parting thoughts,
Please.
and that is, many, if you have hedge funds here, they're going to be part of antitrust claims. In things like FX, Euro yen, Eurobor, wheat, picket. And they're very different because they tend to be collusion or price fixing. Um,
Okay.
and you don't need a loss, whereas typically you need a loss in securities. You don't need a loss. It's just how many times you traded, and there's a number that's put on it. So you're going to have a claim whether you had a loss or not. This is an area that's more difficult, more complicated, even more difficult and complicated to claim because there's no QSIP. So there's no uniform identifier necessarily. And many firms have their own identification system. Um, many software providers or custodians have their own, different security symbol system. So it's a lot harder to file those claims individually. As a
Yes.
hedge fund, you really need to outsource those. There's no way you're going to file those on your own with success or maximize the claim if there's certain ways to maximize the claim. In other words, finding data. FX was like a very, very complicated case. So I would be pretty certain that if we filed it for you versus filing it on your own, you're going to make far, far more with us, and the fee that we charge, you'll dwarf it by the amount of money that we would get for claims. I mean, we got $200 million in FX for our clients. So, maybe more actually, because there have been more distributions. So I would say pay attention to antitrust. I would say pay attention to foreign, pay attention to private litigation, pay attention to direct payment. And if you need help with fair funds, let us know. So those are sort of the, ancillary type thoughts when it comes to the overall world of class action claim filing. I also think, the people in the crowd have to recognize that there's money here, and it's easy to get if you hire someone like
Yes.
us. It's not hard, and it's just free money. I would also suggest that the newer funds that you have here start now, so that you don't have to scramble for data if you leave, Pickett, ABN to go to Goldman to go to Citi. I mean, you want to get that data stream happening from day one, because that's
Sure.
the cleanest data, the easiest data, and it's the old. And sooner or later, it's hopefully it's going to become old data because you're around 5 years or more. So you want to
Right.
get that
Right.
data stream started ASAP.
And for those in the audience that are interested, they can certainly contact you. We have your information up. I also want people to know that one of your colleagues, Jim, Len Belvedere, happens to be a member of Maine, and quite often attends our events. So the audience certainly can reach out to Lenny if they have questions about this. But yeah, this has been quite an eye opener, and I think I speak for everyone that's on the call. And I do want to let everyone, or at least remind everyone, that we will be putting this video up on the website. So it'll give us a day or so. But certainly, you've covered a lot of territory here, and I'm sure people are going to want to go back and reference some of the points you made. And so the easy way to do that will be, of course, to do it off the website. But Jim, again, are there any other points that you want to make while we have while the mic is still live here?
No, Bob, I do very much appreciate this opportunity. Len was actually the head of the corporate action section some years ago. He knows everyone in the industry, really.
Yes.
And so, it's just wonderful what you're doing, and I appreciate it. I appreciate having the chance to talk to your audience.
Well, Jim, we appreciate the fact that you were available for this. And I guess what I really want to know is, what kind of card game are you playing next?
Card game?
Yes.
We
You're
play
shuffling
Texas.
the deck there. Are we doing poker, or are we onto blackjack?
No, we played Texas Hold'em last night,
All
actually.
right. I hope you did well. But listen,
I didn't. I lost in the last hand. I lost on the all-in hand. I had two kings, and the other guy pulled up an ace on the river. It was very
It's
aggravating.
it's terrific to see you, Jim. I do want to, on behalf of Maine, I do want to thank Jim Tharin, CEO of the Chicago Clearing Corporation, for sharing his very valuable insights and experience into a very important bottom line topic for investors. And I would love to have you back, Jim, at some later date. Okay, so we should talk about that. I also want to let the members of the audience know that they should check our website. We're going to have some live events in September and more podcasts in September and October. So by all means, please check the website for the next event. And I hope everyone enjoys the rest of what's left of the summer, and we'll see you soon. Okay? Jim Tharin, Chicago Clearing Corporation, thank you again for your time and for your insights.